And we're live.
Hey, buddy, how you doing?
Good, man. How are you?
Yeah, good to be here, and looking forward to talking about an interesting topic, intellectual property, which I used to think of as very dry as dust, but having spoken to more and more lawyers over time, and most specifically this week with the 10K Collective Mastermind, we had a sort of special guest
Oh,
meeting with a lawyer who turned out to be, sort of make intellectual property feel very sort of user friendly, which is great.
great. Okay,
Yeah,
awesome.
yeah,
Well,
yeah.
welcome everybody as you're jumping in with us. Love to have you give us a little hello in the comments underneath this video. Let us know where you're listening from. We're obviously broadcasting into several places, YouTube channels, Facebook groups, that kind of thing. It's obviously early morning West Coast time. Sunday is probably a challenge, Sunday morning early, but it's the time at work. So we'd love to hang out with you, answer questions through this conversation, and include you in the conversation as we go. Great topic today, man. Building an intellectual property empire.
Mm,
I love this. This is
yeah,
up my alley all the way. Cinnamon
yeah.
and I have basically built for, I don't know, 12, 13 years now, something like that, our whole business around digital goods and intellectual property. And so it's been fun to learn about it.
Yeah.
I think it'll be a great conversation today. Obviously, it sounds like you had a fantastic special guest in your small group mastermind
Yeah,
this
the
week.
difference between that and an interview is it was kind of like one person being interviewed by 10 business owners who, for very
Mhm.
pragmatic reasons, needed to get problems
Like,
sorted. So it
how
was
did that?
really
Yeah,
cool.
they all want to have their questions answered. Sure.
Exactly, and they all have very, very different questions. It ranged from can you copyright, a surname, all the way through to I've got this formula for
Hmm.
a topical, something that goes on or in
Hmm.
your body, and how do I deal with that in IP terms, which
Yeah.
was very interesting. So we had a lot of edge cases, but also the common or garden stuff was dealt with as well. So yeah,
Yeah.
it's really fantastic. Um,
Well, as is our tradition, we're going to formally record the podcast here in a couple minutes. So if you're hanging out with us beforehand, we're just kind of shooting the breeze, and then we'll kick it off, do our podcast, and then wrap up with everybody afterwards. So feel free to leave a comment, say hello, let us know where you're watching from, and ask questions as we go along. So we titled this topic "Build an Intellectual Property Empire."
yeah.
What is your definition before we even start the podcast? Just for people who are watching with us in the recording, what's your definition of intellectual property? Like, what do we mean by that phrase? Is it digital goods, basically? Digital information is beyond that, right?
Yeah, I think it's very beyond that. I suppose it's a kind of parallel universe. I suppose Plato talks about the Platonic ideals universe, where if you've got a chair in the real world, and his idea in the abstract world, there's a perfect form of a chair that represents that. And I guess intellectual property, when you're dealing with physical goods, very different from your business model, obviously,
No.
is that it's like the flip side of if you've got a chair, if you've got a patent for that chair, you've got a sort of schematic diagram of that stored at the USPTO office or with the UK government or whoever else it is that
Hmm.
represents that object. But the weird thing you've got to get our heads around is that representation and your ownership of the rights to that has business value. In some cases,
Right.
really very big value. In other cases, it's just there to defend you selling the physical thing. So
Hmm.
it's like a sort of parallel universe that works alongside physical products, or in the
Hmm.
case of digital products like yourself, I guess that's a bit of a different relationship. And obviously, you're the expert to talk about that because that's not something I've really done.
Yeah, I love this topic. It's really interesting because I've always said to people, the brand is the most valuable thing you can possibly create. Product's not the most valuable thing you can create. It doesn't matter to me what the product is. It will not be the most valuable thing. It'll be the brand that you wrap that around.
Interesting.
And so the brand, and it's interesting because it's intellectual. You
Yeah.
you can, and there's no barrier to entry really. Other than it has to be available to you. But the brand that you create is incredibly valuable. And so I think that's what mesmerizes me about this whole topic is you really can create
Mm.
maybe an empire or at least a collection of valuable things in the digital, non-tangible world.
Yeah.
And so that's the interesting part to me. And so I know this conversation will get into some nitty gritty and detail about how you do stuff, but I
Yeah.
think just at the high level, I think that's why it's most um, mesmerizing is because of those attributes of, the ability for all of
Yeah.
us to create something valuable in that way. So
Agreed. And just to your point, before we plunge into the show, I think it's not an either-or game. We don't have to trademarking your brand, but ignoring patenting your product. Robert Wright, and I'll mention this on the show, but he says the way I was taught about it when he was trained for his masters in that, he said I was taught to think in terms of wrapping multiple layers of intellectual property around valuable things, which is very sensible, doesn't it? So as a defensive strategy, to your point, a metaphor I'm going to steal shamelessly from you in a second is if you've got a castle that's full of valuable things, you want as many moats around it as possible. So, you know, I agree that in the end, your brand is probably going to be more valuable than the other things, but you might as well protect all of it. And then you've got maximum, defensibility.
Totally agree. Well, let's kick this off and jump into the conversation today. So I think you're going to do the introduction to this podcast episode. So take it away, man. Let's get into it.
Okay. Well, let's talk about, sorry, let me try again. Intellectual property sounds like the abstract preserve of intangible products or something for the lawyers to worry about while we get on with running our e-commerce businesses. But we hope to convince you today that it's a very powerful form of property you should look to own in your e-commerce business, both for defensive and sort of brand building reasons. Intellectual property can be incredibly valuable. Famously, Michael Jackson bought the rights to the Beatles song catalogue from Paul McCartney in 1985 for $47 million. And by 2016, that was valued in a Sony deal as $750 million, basically for a lot of sounds that form songs. Well, that's all very well in the abstract world of music. Is it relevant in e-commerce when we mostly own physical goods? Well, Jason, in the introduction to your excellent book, E-Commerce Power, you talk about dominating a niche, being like owning a valuable castle, and you want to surround it by moats filled with sharks and anaconda snakes. So in other words, owning a valuable piece of property or real estate and then vigorously protecting it. So intellectual property, I think, has two really powerful functions for our business. It's a powerful form of everyday defense against raiders to protect what we've built. And it's also a form of property that can, in the right circumstances, have value in and of itself. So I think it's both a wonderful asset class that's mostly ignored and a defensive strategy. And the fact that it's mostly ignored, even amongst otherwise pretty savvy 7 and even 8-figure e-commerce business operators, tells me that there's a great opportunity there that other people are ignoring. So Jason, are you ready to plunge into this, and do you love IP in your business?
Yeah, I am ready to plunge into this. I do love the topics of intellectual property, and I'm really looking forward to the conversation, and just want to make sure everyone is dialed in with us and thinking about this. And I know that I generally speak to broad or e-commerce topics and Shopify site owners and brand builders, that kind of thing. And you're very, very focused with your clients on Amazon sellers. Hopefully in this conversation, we can marry the two together and really talk about it from an Amazon seller point of view, what it means for that use case. And also then brought more broadly in terms of, building business assets and that kind of thing. So yeah, I'm really excited about the conversation. Let's jump into it together, man. Lead us through your point of view on this stuff. And then I'm happy to jump in as well.
Yeah, well, I suppose the first thing we should do is define what we mean by intellectual property. Now, my understanding is that and again, I should preface everything by saying I'm not a lawyer, I'm not legally trained, I'm the son of a lawyer, so I'm like even more wary than most people about giving out unsolicited legal advice. Yeah. So if in doubt, please consult a professional. I'm hoping to convince you that it's worth consulting one is probably my starting point. So having got that out of the way.
Well, let me just
please
tack on at the very top of the show then a little recommendation.
Yeah.
Google around and find an intellectual property attorney in the nearest metropolitan area to you. Michael, you're in London, so it's not an issue for you. I'm in Seattle, so it was very easy for us to find a wonderful IP attorney. Her name's Heather. I've actually referred her to people in the US before that don't know an IP attorney, but the simplest thing is find one in your local metropolitan area that you can chat with, use for the legal process steps in various situations. And I think that's a key thing, is don't depend on Google for your real intellectual property attorney needs. Go find one locally and have a real conversation. So there you go. That's
true. I would also say don't depend on podcasts, including this one. And really, please don't go to Facebook groups if you're an Amazon seller for tax advice or legal advice. I mean, that's just a dumb idea. I mean, if you're going to get advice, get it from a professional. So this is a spark to your you're thinking. Right, but having said that, let's get to it. So I think there are three main kinds in my understanding. There's trademarks, which is probably the best well known, but there's a little known nuance about the differences between the design and utility patents, which a lot of people aren't clear about. The second one is copyright, which is probably the easiest to deal with, the least expensive and the least used. So Robert Wright, who came in to talk to the mastermind on Wednesday, is a big fan of using copyright. And it's, if you're in America, I'm very jealous because you have a fantastic system there for registering it. And the third time is patents. Sorry, I've got this model up. Let me just try that bit again. Patents. Yeah, you could say it both ways. Right, let me try again. So the three forms that intellectual property takes, in my understanding, are trademarks. This is basically if you're going to register a name or a brand, that's probably the best known, particularly for Amazon sellers, because they're frankly got their marketing head on first and foremost, and they want to get access to brand registry and A+ content. Then there's copyright, which is probably the most ignored and is the easiest to use to take other people down if they're copying your property. And in the US, you have a fantastic system for dealing with it that I'm very jealous of. And then the third one is patents or patents. People argue about even how to say it, which is the most expensive and takes the longest. So probably the least attractive, but also underused in the right situation.
Yeah.
So those are the three forms I understand. There's a fourth form, which is a trade secret, such as Kentucky Fried Chicken's famous herbs and spices, but that's pretty unusual, although it does come up if you've got topicals and you've got a unique formulation to a cream that you put on skin, etc.
Yeah, there's other weird nuances, like trade dress is a thing, and that kind of trade dress is like your color palette and scheme and that kind of thing. But those are nuances that are very, fairly uncommon. But the big three that you mentioned, I think, are great for us to talk through and help everybody understand a little bit more about them in today's show. I love that. So registering your name or your brand in the US, that might be different than in the UK. So let's talk. Is that the first one you want to talk through? You want to jump?
Well, I think it's important to really be clear about why we need to bother with intellectual property in the first place. I'm don't spend long on it, but it's often the sort of thing that people are very busy if they're owner operators, and it gets left because it doesn't feel urgent. But I think there are three main reasons, and then one extra one for Amazon sellers. So the first reason is to protect yourself against spurious allegations of infringement from others, and that is not a thing that may happen one day. If you're selling in any kind of visible category, whether it's ranking on Google, selling through Shopify, or on Amazon, that's going to happen, and it's going to happen with increasing frequency the more you sell and the more visible you are. So I really think this is incredibly important. If you get your IP sorted properly, you could be back in days. If your listing gets taken down by Amazon, if you don't have that, you could be suspended for months, and that's a huge hole in your revenue. So it's really a serious thing to get onto straight away and not leave to rest.
Do you have any funny examples of that? I have a few that I could mention that they're just cautionary tales.
I've got a couple, but I don't know if I've got anything very cool. If you've got something, let's hear it.
Well, I don't think they'd mind me saying this. I think it's probably public information, but there was a charity that I interviewed with them and didn't end up working there, but it was called Life Water. And I remember during the time of the interview, they're a California charity, and they do well drilling around the world and that kind of thing. But at the time of my interview, when I was interacting with them, I think it was Pepsi Cola company had come out with their water product line, and it was all called Life Water. And so they immediately were very concerned, and it turned into an intellectual property question. And so I think that, it was interesting because they had to immediately get schooled up on what was legal, what wasn't legal, what standing they had. And it was a situation where I think fair to say a relatively small, organization who saw a massive giant company come in and use their exact same name. And even the logo was very similar. And the question was, what is our rights? What is Pepsi's rights? What just happened to us type thing. And so the legal stuff mattered in that situation, and they had to learn it in a defensive posture or a reactionary posture and mode versus knowing up front we're we've got our terms and brand and all of that stuff on lockdown. We know we have it defensible in the certain specific use cases. And so that was an interesting one to me. I think there are a lot of use cases for registered brands in the US that you have to understand how it works, and what the law does mean. And if you're just new to e-commerce and you're just setting up a brand, you just have to learn this stuff so that
Yeah.
you understand what is the system or process by which this occurs, what's legal, what's not legal, so that you don't, break the law, but also to your point, so that somebody doesn't come in and take away something that you thought was valuable for you, when in fact maybe you didn't own it, So
Yeah, well,
yeah.
I guess it's related to the second reason that I think it's really important to take this seriously from very early on, which is to protect yourself against other people stealing your intellectual property. Now,
Mhm.
okay, Pepsi Cola is a bit of an unusual one. Most of us won't come across a family that something that giant,
Yeah.
but it's often the case that quite big, sort of medium-sized company, not
Mhm.
as huge as Pepsi, will come and allege infringement of
Mhm.
it could be patents, could be trademark, could be copyright, could be
Mhm.
all three. In fact, often is more.
Yeah.
So that's one reason. The other one is it more common that you go to, say, Alibaba and you see that somebody is using your images, or that you go to
Mhm.
Alibaba and they're using a
Yeah.
product that you actually had a patent on. And if you've got a
Mhm.
patent and a copyright, you could use either or both to take them down, which would mean that Alibaba would take it very seriously. And by the way, Alibaba's actually part of it anyway is American based, so they will actually follow US intellectual property law, perhaps to your surprise but also delight. So that's one example. So that again is a very common thing in the Amazon space, and I think just generally in
Yeah.
e-commerce.
Yeah, no, totally agree. And that's the big, that's the huge challenge. But the nuance here is some stuff you think might not be fair is actually legal. And
Yeah.
some stuff that you think might be legal that you're doing is actually copyright infringement. So you just have to learn the rules of the road. It's like learning to drive a car.
Yes.
And driving a car in Britain is very different than driving the car in Seattle, Washington.
Yeah.
So you have to learn the rules of the road. And I think that's the whole point here is you've got to learn the system so that you can understand what is, how to
Yeah.
use it and how other people can use it against you as well, So,
Absolutely. And I think you need to learn, this is what I hope to get out as part of educating e-commerce leaders, is
yeah.
understanding the basic legal principles. That doesn't mean that you shouldn't also consult an attorney, but if you have an understanding of the principles that drive it, just as you have understanding of the principles that drive finance, but that doesn't mean you don't speak to a tax lawyer, then
Yeah.
what it means is you can start to think in a legally valid way rather than that's not fair, which is, as you say, fairness and what they call natural justice and law don't always coincide.
Yeah.
So the third reason to get this right is a longer term one, and for a lot of people it's hard to get your head around. Again, you're dealing with this month's problem or today's firefighting, but it could be costing you millions, which is blocking the sale of your business if you haven't got this stuff on lockdown. Now, due diligence is the boring part with a paper book, and books need to be ordered. I've heard of a $2 million business sale being stopped by lack of documentation of some copyright from some person on, I think, Upwork 5 years ago. That was one thing that Robert mentioned. A member of the mastermind's recently been selling his business, and he said it almost stopped the sale because of an issue around intellectual property rights as well. So again, if you're going to be making a sale worth several $100,000 or million or more, it's a bit silly to not spend a couple of $100 on some very simple copyright tying up, or something more expensive but that is intrinsic to your business, like the formulation of a face cream or something.
It's really interesting. I mean, I think that's the question is, what will motivate us to do this hard legal work?
Yeah, this is a good question.
There's only two motivators, man. There's either a hope for gain or fear of loss, right? And that's really interesting. I think the diligence part of being ready to sell your business is a key factor. If you think you want to sell, then going through that list of what do I have control and ownership of that I do need a document to make sure someone else can say, oh, you own this. Yes. Now I'm buying it from you. Okay, great. Rather than saying, do you really own that? And am I really buying it from you? Yes or no, I'm not sure. So I'm going to slow down the sale, or, oh, that's horrible.
Yeah, I think normally it's not so much a question of slowing down the sale. It's in some cases, especially the more risk averse buyers, it's simply stopping the sale. That's what I mean. It's for want of a nail. The battle was lost, as we say in that English phrase, So it's a really foolish reason not to have got it sorted, but also more profoundly, what is it you're actually selling? It becomes very, it seems very, very abstract until you come to sell a business. And that's why I think every single business owner, even if they intend to pass their business on to the grandchildren, and we've got a couple of businesses I've worked with that have literally done that in the past, that they are like the great grandsons of the founders, etc. But nevertheless, you should be clear about what it is you own and your business owns, because if you're not, that means you're vulnerable to people attacking you, see point one. So either which way, it doesn't matter which way you slice it, you need to be clear what you own and you need to be able to prove it. And then it's very quick and easy if there's a problem. And if it isn't, then you're creating a potential, muddy mess for yourself that could drag out for months. And ironically, is going to cost you a lot more money as well.
Yeah. Yeah. Well, I love this. Let's keep going through this. Now, I also just want to mention for our audience that is watching with us live, pop in questions underneath this video, wherever you're watching it, on any questions you have about this topic so far and things that you want us to talk about as we go forward. So, Michael, take us deeper into this. What do you think is the first area that we should focus on as small business owners in this regard?
Good question. So I got really two answers. I mean, the broad answer I think is probably the most valuable, which is Robert Wright, who I think is my favorite person to talk about this. I know a couple of very good lawyers who specialize in intellectual property for e-commerce, but the other one being CJ Rosenbaum, also very good. But Robert's got a nice knack. He's from Kentucky. He's got a nice relaxed manner. He's got a fantastic knack for keeping it very simple. And he says that the best mentality is to think about wrapping anything valuable you own, whether it's a product, an entire brand, or even a piece of packaging you put time and effort into, in multiple layers of intellectual property. So to your metaphor, Jason, if you've got a valuable little castle, even if it's a very small one, you want to surround it by moats and put anacondas in your moats. So that means really you probably want to sit down and talk over it with a lawyer. But I think, there's no reason, unless, cost is a big factor, that you wouldn't, if something's truly valuable, wrap it in as many layers as you can. So just to give a flavor of the cost, if you've got a product that is giving you sales of, say, $100,000 a year and maybe even a profit of 20, and you expect the lifetime of that to be 3 years or something like that, maybe more, that's worth $60,000 in future revenue to you, or profits. So I think it's very justifiable to spend $1,500 to $2,000 on a design patent, which I understand from Robert is roughly what it would cost in the US, and it's probably easier in the UK because it's a smaller, simpler system. Maybe a couple of $100 registering the images of that product, and then you could, even if you have a separate trademark around that line within the overall brand of your business, then trademarking that for maybe $1,000 if you go through a lawyer in the US or something. And so maybe you invest $4,000 in order to protect 60. That feels to me like an excellent investment. And if you think in those terms, in turning it into numbers, I think then it starts to make a lot of sense. So that's a broad brush answer, I guess, but I think that's the way to look at it.
No, I think that makes a ton of sense. And the weird part about this whole system is you can kind of get away with stuff, and you can kind of do things that aren't actually technically, I'm not saying it's not legal, but you can, for example, many people have just made up a name, started putting it on packaging, started selling it on Amazon, and you don't actually own the intellectual property associated with that brand product. Now, if you're not brand registered on Amazon, you don't care until you want to be brand registered, and then you realize, oh, I need a registered trademark, and so that registered trademark piece becomes real at that point. And I think that's the key thing, is these things become real when they're necessary to you. And it's a weird environment in which you can kind of play business and make believe in these spaces and make real money on the back of non-documented, non-legally put together process. And it just creates a weird environment where you can ignore it a little bit. And that's the caution, is that people would ignore this stuff until it becomes a real problem. It comes back to bite them. So, yeah.
Yeah, as you said, it comes out to your motivation. What I would say is, certainly lawyers listening will be holding their head in their hands and saying UK and US have a common law system as well as a statute-based system. So trademark, for example, is something called trade dress. You mentioned it earlier. My understanding, and I'm not a lawyer, talk to a lawyer if you need to, is that if you sell a product under a type of packaging and a brand name for long enough, then under common law, it's obvious that it's about the origin, really, that you're not trying to dupe anyone, that this is definitely a product made by, VZ Incorporated or, Miles Wonderful Widgets or whatever. And if somebody else were to use Miles Wonderful Widgets, they kind of be expecting your widgets, not somebody else's. So there is a bit of common sense. This is where common sense and common law do often over interact. The trouble is common law in both countries, as I understand it, is based on legal precedent, which is judges making, hopefully, sometimes some common sense and sometimes less common sense decisions, which then get used by other judges in future. But that gets very messy and and people start reaching for law books, and then it's up for argument. What I think is great about registering stuff, which I think, as I understand it, is more possible in the UK and the US, sorry, overall than in the UK, is that it's written down by a government office that's gone through a process, and pretty much everyone's going to take that seriously. It's going to be quick, it's going to be clear, and it's going to be unarguable, or at least fairly unarguable relative to that. And I think that's the point: is documentation by a government agency is the biggest club you have in your bag to defend yourself, really.
So registering your brand is the first thing to focus on if you're operating under a brand, and that means if you have a domain name that you use or a name of your product that you've gone to market with on Amazon, you want to have that be a registered brand name. The process, I've gone through that several times now in the US. Generally speaking, for us, it's taken about 9 to 12 months. And, I think $1,200 to $1,800 was sort of the range we paid. We always felt like it was wiser to go through an intellectual property attorney than to just use the boilerplate paperwork system tools that you can find on websites, But you can use tools and automated systems. The problem is if you do that for a registered trademark in the US, at least, there's a period where other people can challenge what you're doing and you have to respond. And those are the moments in which you want an intellectual property attorney, because you're like, what is this? How does this work? And an IP attorney will be like, okay, this is how it works. This is what we do right now. Here's the process. And so anyway, so that's sort of the registered brand, thing. Now, technically in the US, I don't know how it works in the UK, but technically in the US, when you apply to have your brand registered, you can use the TM symbol next to it. And then when you receive the registered trademark status from the uspto.gov website, then you get the R symbol that you're supposed to use, the registered trademark. I don't know if it's that way in the UK for those symbols, but
I don't think the symbols work in the same way, but I'm not honestly sure. I think you can use a TM symbol. I honestly don't know, but that would be a quick Google to tell you that. That's fairly straightforward. But I think, sorry.
Many people use the TM because they've seen other people doing it in practice and don't ever actually realize it's tied to sort of it's a symbol system tied to a process in the US. And but anyway, so that's nuance, but neither here nor there. The point is you want to go through the process and learn how it works. Yeah,
definitely. I would say there is a case for not using a lawyer at a certain point, and I would say that's if you're starting off with a brand new product line and you don't have a big budget and it's not got proven value yet. I mean, that's there's arguments. If you're in the US, I would be more inclined to use a lawyer because it's a much more complex legal system. In the UK, it's a fairly straightforward place, and you can trademark something for about £200 or $250 plus maybe £50 per class. And we'll talk about what class means in the second one. Your understanding of it and mine might be different because we're not lawyers, but it's pretty inexpensive. And if you've got a product going out there, you've done your due diligence up front, at least you're not going to get sued by somebody or an allegation and that you're using somebody else's trademark, which is important. And then if it proves valuable down the line, I'd probably get a lawyer to double check your work. But I would say that if you've got an established brand that's valuable, I wouldn't mess about with that. I would just go straight for a lawyer.
So you mentioned classes. Do you want to talk through that a little bit? Just the nuance there. So
so my understanding is that there are, I can't remember how, is it 40 classes in the US and something like that in the UK? Maybe it's 35, but it's probably going to change in a couple of years anyway, the nature of these things. And broadly, it relates to the type of products that you're selling. So if you're selling, kitchenware, it's not going to be the same as software, which isn't the same as legal services, obviously. So you'll end up in probably want to do to register in 2, 3, or 4 classes where you even think you might have a challenge from a similar company. So there's a sort of grey area. So if you're selling cookware, but it could be used in the garden, I don't even know if they're separate classes. But for example, you want to just cover all the common sense bases and don't be too stingy about the fact that maybe if you're using a lawyer, it costs you a couple of $100 extra to register another class or something. I think you should be generous, as it were, and cover as many classes as you think you can claim, and that gives you the broadest protection.
Yeah, that's where it can really become confusing, and there's nuance, So I always use the example for people who are familiar in the U.S. probably with a school called Old Dominion, and then there's a trucking company called Old Dominion. Well, a university and trucking companies, same exact name, completely different industries. And
Yes.
so that's the
Yeah.
way in which you think about the registration of trademarks. Now, you can register in different classes of business um, if you're going to operate in them. And the question is, are you in a category that's similar to a competitor? When you go through the process, that's what a lot of the attorneys are looking for is there a name structure that is in our class that is too similar or identical? And when they're identical, it's obvious, but when they're similar, then there's still process for that old established company to say, what's happening right now? So that's the classes are sort of the nuance of how to do the registered trademark process. And it's something to learn about and understand. And that's where, people can get confused about what's legal and what's not legal. I had a funny example of this. We I think I've said this in another podcast before, but it just always cracks me up. Is we had this we name all of our outfits. When Cinnamon does a design, she'll name it something, and so she has this whole Australian line of Outback clothing, and so she had this one design, and we called it Boomerett Falls, because that's like a waterfall in the middle of nowhere in Australia. And we looked on a map and named it Boomerett Falls. Well, I got connected by this guy one time in Australia who was so adamant that he was going through the process of registering his IT company for baby boomers, and he was calling it Boomer IT. And Boomer IT is Boomerett, which is the name of this waterfall, is the same URL. He wanted to use the same URL. And he was convinced that I need to do something different. But the problem was we had done that work like a decade earlier, and it was all over the internet. The internet was ensconced with our use of the phrase Boomerett Falls for this design idea, and he was demanding that I stop using this phrase because he was not even he didn't even own it. He was just going through the process, and it was so comical to me. I said to him, first of all, that's impossible. Second of all, are you an attorney? And he was like, no. I was like, well, I said, no disrespect, man, but that's not how any of this works. And so it was a hilarious example of, number one, don't act like you know what you're doing if you're not an attorney and you don't know it, because it's one thing in just your own country, like in the UK, something, in the US, you think you know something. But if you try to go international with this stuff, it gets particularly thorny because there's different rules in different places. So all that to say, these classes become an important part of it, and understanding where people have rights and where they don't have rights, and where you have rights and where you don't have rights. Yeah. Anyway, long story to say, it's important.
What I would say also in a couple of places, one of the things with IPO, I've been going through the process with a client who's got a new business, so he's not trading yet, but it's still been interesting. So the more I learn about this stuff, the more I get people to go through the trademark process earlier and earlier in the process these days. But sometimes if budget doesn't permit to do DIY trademark registration in the UK, I have to say I did send this chap to talk to a couple of lawyers first, so I feel okay about that. But he made his own decision. But what I would say is two things. I mean, first of all, you want to probably avoid any grey area. So if you sell homeware and you're called Marvelous Products, and somebody else sells, I know, garden furniture called Marvelous Products, for me, that's too close to comfort. I would just change the name if I had a chance up front. And if I discovered there was a place called Boomerett Falls and I hadn't been selling for 10 years using that brand name, I'd probably choose something different. So that's the first thing. Just avoid any sort of near brushes with things that are similar enough in category or class that they might conceivably cause a problem, because even if you can see them off, that's going to cost you lawyers' fees as a distraction from operating your business. The second one is nothing like as nasty or defensive, but it's called descriptive. If your brand name, for example, if you sell quality homeware products, you probably can't call your brand quality homeware because that's just a description of the products. And in the UK, I've seen quite a few rejections of trademarks on that basis. It's not something that the UK authorities are going to really shake a big stick at you about. As I understand, in the US, they will just reject it and tell you why. And at that point, you probably do want a lawyer in your back pocket. But the best way around that Robert Wright's very fond of, is simply making a name up that sounds like a name but isn't anything. And therefore, it is genuinely unique. The downside is it might not feel very descriptive of the products for the consumers. So there's a bit of a balance to be struck there in terms of brand naming. Oh, you're muted, Jason.
Yep, totally agree with everything you just said. It's really wise to come up with a novel thing. And In the e-commerce power book, I use this example where it's like Ray's ice cream with a Y, and Ray's ice cream with an RAE, and a few other variants. And the question is, what's legal? In your mind, you say to yourself, can I have this be my name? But the truth is, all of those are failures because it's just not unique. There's no novelty. And so what you want to do something that is novel. Compound words where you combine two words is a good strategy, as you just mentioned. Neologism is a new word where you make it up, and those are all really good ideas. And it is hard. It is hard to come up with something new. I've many times have tried to come up with a brand name, searched locally in Washington State, and there's already a business called that, and then searched for trademarks or just broadly on the internet, and then you find out, 22 people use this already, or are all fighting over this phrase. Like, I don't want to be the 23rd person battling out for this name, and so it can be very hard. But your advice is super sound, which is avoid similarity, and if you have something that's similar to something else that's already out there, start over and come up with a novel, unique thing. Yeah,
not worth it. The thing is, some things are worth fighting over and spending money on lawyers to defend, but a mediocre name is probably not one of them. Unless you've been training on it for 10 years, in which case I guess you've made your bed, you're going to have to lie in it. But if you have a choice, then I would consider changing that. So we ought to talk about brand registry, because it's one of the most, for Amazon sellers, and I know it's not relevant to Shopify, so I'll keep it brief. But one of the reasons that you want to get a trademark, and frankly, most people do that, is to get access to A+ content. But also, brand registry also means you get access to Amazon's system for kicking trademark or any kind of intellectual property infringers or alleged ones off the platform. And that goes two ways. If you're going to sell on Amazon, you absolutely should get on with brand registry, because then you can do the same things other people would do to you. But equally, in that environment, you kind of basically, they'll shoot first and then ask questions later. And the reason why is because I understand that the DMCA, that the Digital Millennium Act, meant that Congress said that marketplaces like Amazon or eBay are not liable for IP infringements if they act promptly. So that means that basically alleging that somebody's made IP allegation means that they act as if they have, and then it's kind of up to them to prove their innocence. Now, if you're on the other side of that, once again, having documentation of everything possible, copyright included, is a really smart idea. So to get done with that, you basically need to do one of two things. If you've got a UK trademark, you can get access to brand registry for A+ content and the brand analytics, which are very valuable, but you want to be aware that it will not protect you against IP infringement claims. So in the end, if you're going to sell in the US, you want to get a US trademark, and the same if you're selling a UK, get a UK trademark as well.
Sure.
So I think you had some good hacks for getting through that reasonably quickly. What are your thoughts on that, if you know?
Well, I mean, all I know about Amazon is what I hear Kyle talk to all our coaching clients about when we're on our joint calls with our coaching clients. That a lot of folks we work with are fantastic Amazon sellers. And so this whole process, I think, is very helpful now that Amazon has basically created a system by which, if you haven't gotten a registered trademark, you can, as I understand it, correct me if I'm wrong, or go research it yourself, but Amazon has a process now by which you can basically go through their system to apply for your registered trademark with attorney groups or whatever law firms that they've vetted and validated, and they give you basically a fast track to be brand registered if you're in the process with a vetted firm they use. Super helpful, super nice. Now, again, I'm not an expert on this, but go check it out. But that's really a nice fast track to get the A+ content unlocked and all that kind of stuff on Amazon if you haven't gone through a traditional registered trademark process. How you can speed it up beyond that, I don't know. I've always done all my registered trademark stuff outside of the Amazon universe. It was never my area of focus when I was doing it. At least in the US, I know that there have been periods where it's been slower and then periods where it's been faster, where literally, it just I think at one point for one of my trademarks, it took like 16 months or 18 months because it was just a slowed down season of their workload, or I don't know what, if government strikes or something. But frequently it's like, 9 months or something like that. But for the Amazon people, you do have this sort of backdoor. If you haven't done it yet, you have this sort of use Amazon's process and they help you expedite it, at least for their process. That doesn't mean you actually have any registered trademark protections or anything outside of Amazon. They're just allowing you to kind of speed things up for them on their side. I do want to talk about DMCA for a moment. If we can talk through that.
Yeah.
So the Digital Millennium Copyright Act gave a process by which you can challenge intellectual property claims on marketplaces and websites. And so as a marketplace operator, what that means for me is I have to have a process in my marketplace, my website, Pixie Fair, to receive a complaint about intellectual property and then manage that complaint. And so Amazon also has to have that process in place. And obviously, with my universe of my marketplace is tiny compared to Amazon, but they had to do this at scale, and so they had to have a process by which they understood who was the registered trademark owner for all of these various named items and products and brands, and so it's great that they've gotten it sorted out. And the DMCA process is not new; that's like old. That's like really old. But Amazon's just, come to this process that is actually, I think, very valuable, especially for people who had a lot of sellers camping on one, a branded product where there was question about, kind of did the company who was actually the maker and manufacturer even control of what's happening on Amazon? You hear those scenarios where it's like, oh my gosh, it's like you're not even in control of what's happening on Amazon in your own, with your own product because of your sales channels and all that kind of thing. So I think it has helped tremendously, as far as I understand. I don't know your thoughts on that, but there you go.
Yeah, I think Amazon's kind of come up to speed with what was needed, really. I mean, the main thing I would say is, I guess it kind of functions if you sell primarily on Amazon, or for the part of your business that is on Amazon. It's kind of effectively a legal system within itself, based on a principle that most legal systems do not share, which is you're guilty until proven innocent. You need to be very, very aware and prepare accordingly. This is like the theme of the whole podcast here, isn't it? That just because somebody hasn't taken you down yet because you've only sold 10 grand a month with a couple of products doesn't mean it isn't going to happen when you get to 50 or get to top of page 1. And if they do, what can happen seems very unfair. In the normal law court, somebody would make an allegation, you'd wait months to go to court, then in court they'd have to bring evidence beyond reasonable doubt in the criminal court or beyond the probability of it's in the lawsuit, and then after that they'd take your products down. On Amazon it's the opposite. Somebody alleges something, your listing's gone within 15 minutes possibly, and then you need to prove you're innocent. So once again, if you do sell within Amazon, although it does obey the laws of the United States or the UK, similar with eBay, probably because ironically the pressure of the acts that are passed pressurizes them to protect themselves such that they will take things down immediately if there's any allegations. So you need to be prepared for that, and you must have your paperwork in order. Otherwise, hope is not a strategy. They always say that in the Marines, I understand, but it seriously is not. If you've got a messy sort of trail with missing pieces to it and no registration with the government body, it could take months to get reinstated. I've seen it. That destroys businesses. So just don't take the risk, is what I would say in that.
Well, we just camped on trademark for a long old time.
We have done.
Let's move on to the other two forms of intellectual property we want to talk about today, which is the second one was copyright.
Yes.
And so I think that's really important to talk through. So you want to kick that one off for us and we can walk through that?
Absolutely. Yeah. So copyright's Robert Wright's favorite thing. And as I say, he's a man who likes to keep it as simple as possible, which, by the way, is unique in a lawyer. As a lawyer's son and know a few lawyers through business dealings, never met one who likes to keep it simple. So this is a wonderful piece of news, I think. So the first thing about copyright, like a lot of other things, if you create a work of some kind, like you take a photograph or you write some copy for your listing, or you create a beautiful box design, or you do some infographics, all of that is automatically copyrighted under common law in the UK and the US, as I understand it. And there is a nuance there which I ought to mention, which is if somebody else creates it on your behalf, just because you own the photos doesn't necessarily mean you own the rights to use the photos, or you may implicitly have rights and whatever, and it could get very, very nuanced very quickly in a way you didn't want. So the first thing is make sure you get in writing from anyone who creates anything for you the fact that they're assigning all rights to you. Some of the platforms like Fiverr recognizes the fact that this is an issue, and it's part of its standard agreement between anyone who hires people on the platform and the gig workers there, that unless otherwise stated, that you get all the rights. Unfortunately, Upwork and other such platforms don't automatically do that. And if you hire somebody through a friend or whatever, or you go through a more broad hiring process, that's not necessarily the case. So that's one thing to just nail down that is very quick and easy. You don't even need a lawyer. It doesn't need to be notarized. But if you don't have that, then 5 years down the line, like this US firm that Robert was helping with their intellectual property, they were trying to, an Australian company, they were trying to sell a $2 million business. They hadn't documented some rights to use some photos that were done on Upwork 5 years before. They couldn't find the guy, and it nearly scuppered the deal, except that the people buying it realized that they was probably going to lose a good company for silly reasons, but it certainly slowed things down. So that's something you want to avoid. Just get it all in writing.
Yeah, right. Sure. There's a lot of nuance here, I think, for creators. Ol asked the question as it relates to registration and trademark as it relates to handmade items and that kind of thing. And this is the space we've operated in for I guess since 2007. One of the things that's important to understand for creative work is when you've created concepts, intellectual property, and you've published them and you own them legally, or formally or informally, there's process for both steps, but either way, it's your content and your intellectual property. What you don't want to see happen is people make money on the back of your intellectual property. And frequently we have this all the time. This happens all the time on marketplaces like Etsy or Amazon Handmade, where it's like, oh, I'm making the Baby Yoda shot glass. Disney doesn't sell Baby Yoda shot glasses, so that should be fine, right? And what you, as a creative, like a craft seller, frequently you can think, my product I'm making is the thing I'm selling. But as soon as you use someone else's copyrighted or concept to make the sale occur or to make the item more appealing, you're camping on someone else's intellectual property, and you're really stealing from them. And that's an important concept to think through, because the shot glass with no Baby Yoda on it is not valuable in the same way with the Baby Yoda shot glass. And and you just have to learn that as you get into the craft and handmade and those kinds of industries. And the biggest problem we've seen over the years is people will copy other people that are breaking the law. And so basically what you'll see is a lot of people will come in and be like, oh, I'm doing this. And we're like, yeah, that's illegal. Well, tons of other people do it. Like, yes, that's true. And they haven't gotten taken down yet off the websites, and they haven't gotten busted yet, and their products are being listed and sold. But nonetheless, it's still a copyright infringement. Yeah. And that nuance is super important to understand. And it becomes clear to you when you get a cease and desist letter from a big company, but it should become clear to you well before that, where you ask honest questions about how you're monetizing and making money with your products, and whether you're in essence stealing from someone else in that process,
Yeah, that's a very, very good point. And I guess another way of looking at it is to assume it's a bit like land. I mean, in the US is such a big country, this is probably less of a thing, but Europe's very, very, very crowded. It's been the landscape in the UK was changed by humans 10,000 years ago. Sure. It's just human modified. There's no piece of land in the UK that isn't spoken for. So if you come across a piece of land and start building a house on it randomly, the chances are exceptionally high that at some point somebody's going to come off and force you to take it down, and possibly arrest you if you don't, because everything is owned by somebody. So the simple question I would ask is, who owns this? If it's nobody, it's probably because you made it yourself, and in which case you need to find the right kind of protection. Just a small nuance here, and this is why it's worth going to lawyers to get clear about stuff, I guess. I would say if you've got a Baby Yoda, that's a trademark infringement. If you've got a picture of a Baby Yoda that somebody else took, that would be a copyright infringement. So that's a neat little example. Nuance, But if you made something like a Baby Yoda or whatever it is, baby something that's a cute kind of thing that people love and it causes products to sell, you could own the trademark in that. You could own the copyright in the image. You could own the copyright in the actual sort of graphic of a cute little thing. You could own the copyright in the way that a photograph was made of a mug with that on, etc. So you can wrap yourself in layers of protection. The flip side, as you just mentioned, is that you could be breaking about 10 different intellectual property laws at once if you just copy somebody else. So again, it's two sides.
Yeah.
Go on.
Yeah. I was just going to say, I always encourage people to just create their own unique concept, their own unique animal, their own unique, named thing, or a design idea. And so I think that's the encouragement, is come up with your own novel, intellectual property idea. If and that's the best answer. And don't make sales in the back of other people's. So that's one piece of this.
Yeah.
There are a lot of other slivers of this or other topics to discuss, but what else is top of mind for you on?
So I think the simple thing is this. I mean, get great photographs done for your products, which you absolutely should do. You spent money and time on them. I've just went through a process with a client who's launching his first product. I try not to work with new clients because it's exhausting, because not only have you got to teach them everything, but you got to do it as well. But we spend a lot of time and effort on it. It's taken, I don't know, 50 man hours in the end, or person hours. Now that's worth protecting for that reason, and it's also worth protecting because it will help sell the product. So you should copyright all of your images, and in fact the whole listing, including the copy as well. And my understanding in the US is that it's the easiest way to do that is to go, you can use a lawyer, or you can go direct to the US Copyright Office, and for a couple of $100 you can probably protect the intellectual property in a listing, which for me sounds incredible value, because great photographs will make a huge difference to the sale of a product over the period of its lifetime. And for me, that's a no-brainer to get that done, because quite often what you'll find is that if people are copying your product, particularly in China, that you'll see not only will they copy the product, which is a patent infringement, but if you don't have a registered patent, that's a bit hard to deal with. But they will often make it easy for you to take them down, because they'll copy your images as well. So quite often, even though what you're concerned about is somebody on Alibaba is selling your product or the product design you've uniquely made, the way you might actually take them down is much more straightforward. You look at their images, you compare them to yours, you register a complaint with Alibaba, and you say, here's my copyright number with the US office, and that's a pretty straightforward route to just get that taken down.
Yeah, the international challenges of this are hard to deal with. The reality for a lot of people is, if you have intellectual property that you own, the simplest way to have enforcement occur is when you see the malpractice occurring on marketplaces, because the marketplace to the DMCA takedown process is responsible. And so that's why if you see people selling your stuff wrongly on eBay, and this is true for our business, we do this. This is real for us, not theoretical. If you see people selling wrongly on the big marketplaces, you can work with the marketplace to get it resolved. The bigger challenge is if you see people selling your stuff wrongly on their own website, or in ways that you can't easily remedy without like real lawsuits and that kind of thing. And then it always comes down to a cost benefit analysis, like, is the juice worth the squeeze to pursue this stuff? And it can be very hard. But if you have an IP attorney who can issue a letter for you to people, that's helpful. But that's the challenge. Now, there is a couple categories of copyright and intellectual property that are ungovernable or uncontrollable. Public domain is one, so things in the public domain, and then utilitarian items. And so there are things that you cannot own a copyright for, because they're referred to as utilitarian items. And so, you just have to work with an IP attorney to understand those nuances. A lot of times people think, well, I can use public domain items and make money. And that can be true, but you want to look to see how that's doable, and to make sure that actually there isn't claims made against those items already that you're not aware of. But there are those categories where there's more nuance and gray area, where it's like, okay, the law doesn't apply to these areas because of certain, or they're categorized as utilitarian for the public good or that kind of thing. So
what I think is interesting is there are certain stages of business growth where certain things are appropriate. And what I think is that the startup mentality, which means you just do stuff, they just do it, quotes unquote, where I've just infringed, by the way, on a trademark by Nike by not asking their permission. There's an example of how easily it's done. If you take that mentality at the beginning, you'll get started. If you go to lawyers and accountants before you do anything, then you'll probably scare yourself out of doing anything. However, if you're serious about building a significant brand, I think what you just said is really important. It's a very amateurish way of building a business to build on. It's a bit like buying a house or building a house online where you haven't got a professional surveyor in. It's just it's foolishness. It's foolish ways, and penny wise, pound stupid, as they say here. It's foolish way of saving money. What you've just referenced, by the way, I think we ought to discuss, which is enforcement. It's as Robert Wright said, and this is an incredibly simple but profound point, is it's one thing to create intellectual property in terms of registering things with the government. It's another thing to enforce it. You see, I have to budget and you get your head around and make your peace with the fact that you will have to enforce this stuff. If people are using your images on eBay or Amazon, it's no good registering your copyright if you don't then have somebody look for it. Now, you don't necessarily need a lawyer for this. I know somebody who's got a VA whose job is to simply spend their life on eBay looking for people copying their product images, and sometimes on Alibaba. Now, although Alibaba is a kind of foreign entity, but it's actually also got a US company listed on, is it the NASDAQ or the New York Stock Exchange? So from that point of view, they will actually respect US intellectual property law, but you have to have somebody looking for it, and that is a job in itself. And you have to make your peace with the fact that when you get something wonderful, people want to copy it, and therefore you have to spend time not only creating the legal right to defend yourself, but then you actually need to make the effort. So it's a bit like having a law in a country. That's no good without the police to enforce the law. So those are your police, policing the internet for you, and that's actually a big job that you need to think through.
Yeah, and sometimes you just realize that there's areas of your business that you have unintended consequences. Like, our Pixie Fair site has over 3,000 patterns documented. That's all intellectual property. But when we first noticed that Chinese manufacturing companies were buying our patterns and then literally making the garments and selling them through their supply chain, we realized, oh, okay, so they're taking our intellectual property and then monetizing it through their supply chain in a way that we're not. We don't manufacture at scale, and that was an unintended outcome for us, and we had to grapple with: do we care? Do we act? Do we not act? Do we benefit in any way? Does that hurt us? Does that help us? So there's nuance in this stuff that's sort of weird. So okay, let's move on to the third and final category, which is really interesting one as well, and that's the issue related to securing patents for your work, right? And so let's talk through that one.
Patents or patents? I've never come across. Yeah, I don't know which one it is. It's a bit like tomato, same thing. Yes, so they sound very expensive and difficult to get because a lot of people confuse two types of patents or patents. So the first one is a utility patent, and that is very broad, and I understand it can take tens of thousands of dollars, maybe $10,000, and maybe up to 5 years to get. But it can last for 20 years. If you manage to get one, that's incredibly valuable. That, as Robert Wright says, he's never really seen anyone in the e-commerce space that he's come across do that. It maybe there's the odd person that does that. But that's probably the reason most people have put off patents as an entire class. And that's a shame, because design patents are much easier to get. It can take, I understand in the USA, one to 1.5 years average. I suspect the UK is probably quicker just because the US, everything's bigger and more complex. You got federal law, you got state law, you got goodness knows what. But it can cost really, the budget that Robert Wright will give is about $1,500 to $2,000. So actually, we talked about that before, didn't we? There, that's actually, if you're selling a product that can make you $60,000 in profit over the course of its life, that's pretty well spent money, I think. But there is a caveat. So as you said, if you register a patent, what you're basically doing is publicly registering and telling the world how to make something in a very detailed way. So there is no point, not only is there no point in doing that if you're not going to enforce it in the way we're just talking about, policing it, but you're actively creating a problem for yourself that you're then going to have to go out and police and enforce very rigorously. So really, you need to decide if you're all in or all out on that one, because registering a patent and then not only checking whether people are infringing it, but not actually being willing to do what you need to do to take them down, you're actually damaging your business more than you're helping it. So that was a very interesting nuance. I thought that intellectual property creation and enforcement are two sides of the same coin, and the enforcement is just not something that occurs to you unless you've been through it, I guess.
Yeah. Of course, my business partner Kyle has a brand he runs with his business partner, a guy named Gary, and they did design patent work on their packaging, actually, for one of their products, and because it was a really novel packaging concept. And to me, as I think about that, first of all, it was really interesting packaging, and it was unique to them and their category. No one else was doing it that way. But I think as I reflect on how they did that, to me, the value is in the total asset control that's of what they've created, so that they could in the future sell that and say, yeah, we have a design patent on this interesting part of our product, and that makes them more valuable. Just that it makes their if they ever wanted to sell, that makes it, I think, more valuable to say, yes, this is novel, this is interesting how we've done this, and here's a design patent to to document the fact that it's ours. That to me is interesting work. And you're right, I think it does imply an openness to the universe in terms of how something's been done. Of course, there's beyond patents, there's open source work deliberately is done sometimes in intellectual property space. Some people are open sourcing their code or their system or process for the betterment of humanity because they want to spur people on to do similar things. And so, that's an interesting angle as well. It's where it's like you could get the patent, but you don't, but you open source it, meaning you put it all out there for free for anyone else to see how you're doing something. That's a unique case maybe, but Elon Musk is in that category in a few ways, and other people, Jack Dorsey is doing that with crypto business he's building. And I think it is a very interesting space to think through when you do want to have something be a secret or private or intellectually protected, and when you want it to be open and public and other people know what you're doing.
By the way, there's the third category, which is when something was protected and then it isn't anymore,
Because
which is
no
why
longer-
fidget spinners became incredibly popular in 2016 because they've been under a design patent, I think, or no, probably.
I didn't know that.
I'd imagine
Okay.
a utility patent because it's quite broad. So, then after 20 years, it lapses, and obviously the lady who did it either didn't want to bother, or it died, and her estate wasn't interested, or they didn't know what they had, and that's why suddenly everyone in the world started selling fidget spinners. So that's a third version where somebody created it possibly for the betterment of humanity. I think it was for autistic kids, wasn't it? And then it gets commercialized to the nth degree. But again, that kind of proves why you want to have something unique and then protect it, because actually that was an example of everyone copying something that was no longer unique because everyone had the right to do it. They did, because that's what Chinese factories do. They all copy each other. And so that leads to a sort of race to the bottom very quickly. So I guess that's part of the sort of drawing this to a close. It's part of the mentality you have of creating something unique and going to that trouble, and because it's more unique from the marketing perspective, and then protecting it legally, which means you can take down other competition. So anything that your ideal buyers can see, your competition can see. And the only way to square that circle is really to intellectually property protect things so that your buyer, your competition can see this desirable product, brand, color scheme, whatever it is, photography, but they're not allowed to copy it, and you're willing to get your hands dirty and enforce that in whatever ways you need to, whether it's just writing on the Amazon platform and getting it taken down very easily, or whether you even occasionally perhaps take somebody to court. So I think it's as much a way of looking at business as it is anything else, really.
What you just mentioned about the fidget spinners is interesting to me because it kind of creates the entrepreneurial mind in me. Says, there are probably a lot of people who have done work to create original concepts, to have it even documented, who maybe haven't commercialized as well as they potentially could have. And the expiration of, kind of the patent allows for a broader commercialization. But I would just say there are a lot of businesses that are closed every year. There are a lot of businesses that are for sale. And if you're thinking with your, acquisition hat on, you really want to look through what's out there and what could be potentially for sale that somebody's just never made revenue off of, but was actually an interesting or good idea that has maybe gotten the opportunity. You could have an opportunity to commercialize something where someone else just wasn't able to do it. Maybe they were the mad scientist who maybe just didn't have the sales and marketing chops. And I think those are interesting opportunities as well. So
100% agree. I mean, I know a couple of examples of that. One of the members of the mastermind, Ashley, is currently looking into buying websites because he's getting big into SEO, and he's starting to do that for the members of the mastermind. But that's part of then suddenly gets you into the intellectual property area very quickly. And as part of that, he's starting to realize this same thing. Somebody else I know, Dana Derricks, who's sold on Amazon for a while and was an Amazon copywriter, bought a formulation for some kind of animal kind of supplements. He happens also to be a goat farmer. Go figure, he's a unique human being. And so he kind of knew a bit about that, and he realized the value of that, and that he knew about animals and how you should treat them, and that he can monetize that on Amazon. And I think he bought the formula for $3,000, which means he can go straight to a contract manufacturer. It's probably got the right certification and everything else, if you're lucky, which could cost you thousands to get, and say, make this. It's already certified. It's unique. He owns the patent on it and the formulation, probably some kind of trade secret, I guess. But anyway, which way you can then use that to fend off the competition. So you're absolutely right. I think right now is an amazing opportunity for that, with a lot of businesses that have built a lot of, whether it's brand equity, so it could be a trademark, whether it's formulations like we just said, where they've got beautiful images you could use and buy the copyrights to, that there is an amazing opportunity there if you get outside the box and start, really looking broader. I agree entirely.
Back to the title of this, conversation: how to build an intellectual property empire. Some empires are built from scratch and a novel original creation. Others, you just buy and buy and buy. You acquire companies, even small companies that you can make big. And there are many ways to approach it. So I think getting really good at this set of topics, the IP issues, allows you the ability to then operate in the space in one or the other or both. And Cinnamon and I have purchased, I think, 12 companies now in the last 2 years, where our purchasing was all about the intellectual property. So that I'm speaking from my last 24 months of work, and that is what we're doing, in addition to creating our own intellectual property. And so that could be a whole different podcast. But
I was just about to say, you're not getting away with that. We're going to definitely have to talk about that insofar as you're able. If you can't, you don't have to shoot me afterwards for revealing secrets under NDA. That sounds fascinating. So absolutely right. That's part of the bigger picture. And as you say, the more you look into intellectual property, just to sort of bring this home really, the more, exactly as you said, I think of it as a very overarching knowledge set and understanding that whilst you should never substitute for getting a good lawyer in, I think this is why I justify talking about it as a non-lawyer, because as the entrepreneur, I think you have to have a firm grasp on finance, and that's the really grown-up people. They start off by thinking marketing's everything, and then you realize you can sell lots and lots of money and give 100% of it to Amazon and your supplier and whoever else is involved, or Shopify. And then the next level of sophistication is finance obsession. And the really smart people I know are obsessed with that. But what you're talking about is another layer of sophistication, I think, which is understanding the legal thinking and understanding the landscape, which then I think goes into being entrepreneurial. It's not just a specialist thing you hand to a lawyer and forget. It's part of your strategy, and that's super smart. And I'm definitely going to grill you on or off air about those acquisitions. I had no idea you'd been doing that. That's super cool.
That's an interesting hierarchy you just outlined. Yeah, that's very interesting. So we just unlocked several open loops for
to be continued. Yes.
Yeah. Well, let's wrap this up. So if you're listening to this live with us, thank you again. It's always an honor to be able to chat. And for those of you listening via the podcast recording, we're grateful for your subscribership and your reviews and all that stuff. We did run a contest in the month of July, and we are going to announce the winner next week in our live podcast. And we're grateful for everybody who entered the contest. And so, it's fun, and we're going to probably continue to do that. So we'll kick one off here in the next few weeks or so. We'll see, but maybe we'll skip the month of August and go for one in September. But it's an honor to be able to have people participate. It's an honor to have people jump into our contest. If you're listening to this live with us, of course, we'd love to have you check out the podcast on your player of choice and subscribe. Spotify's my player of choice. I don't know, Michael, do you have a player of choice that you use? We've never really asked each other that
tend to use Apple Podcasts. I don't think any podcast player has really cracked the way that you discover things in a very good way compared to Google or anything really. It's podcast, because I'm kind of Apple loyalist, but actually it doesn't really matter. They're all kind of the same. So I would say whichever system you're on, we'd love to get you subscribed. Although I would just say, from the selfish point of view, if you're on Apple Podcasts, you can give us a rating with stars, which I don't know if is possible in most platforms. So for that reason, I'd encourage you to give us a rating on Apple Podcasts.
Awesome. As always, man, fantastic conversation. Really, really love this one. And thanks, everybody, for hanging out with us today and subscribing and listening to the e-commerce leader with us. Thanks so much. Okay, that's the podcast. thanks everybody for hanging out with us. Really grateful. Wonderful conversation as always, Michael. It's great stuff. So.
Yeah, interesting. And thank you for your much bigger picture thoughts. And yeah, we'll have to that we've been thinking about podcast topics recently. I think that one about buying businesses has top of my list to find out how you've been doing that. It's quite amazing.
Sure. Okay, good stuff. Awesome. And thanks for the positive comments as well in the chat with us. All right, let's end it here. And thanks everybody. We'll see you next week for the next episode. Yep.